Hello, I'm going to make a start now. It looks as though we've got just over 20 participants who've joined so far. It's not quite the number that we expected, and as I speak, numbers are joining. But I'm hoping everybody can hear me, or if you can't, if you can see my lips moving, but you can't hear anything I'm saying, then I'm hoping somebody will send me a message in the chat function. So assuming all the technology is in working order, I'm going to kick off them. Firstly, by just introducing the seminar. So I'll start off by welcoming everybody to this One Pump Court seminar. The title is How to Use the CPR Tactically, Tips and Tricks for Drafting Statements of Case, Witness Statements and Obtaining Information and Disclosure. I'll be presenting the first part of the webinar, and then I'll hand over to my colleague Nicol, who will deal with the second part of the seminar, and that will be focusing on drafting statements of case and witness statements. Okay, so in terms of my section of the webinar itself, I just want to kick off by starting with a case that I dealt with. This case actually concluded about a year ago now, and it involved a social landlord who'd applied for an antisocial behaviour injunction against its tenant. They were relying on numerous allegations. If I remember correctly, it was something in excess of 80 allegations were being relied on. And within the proceedings, they were directed to provide disclosure and inspection of the tenant's housing file. The only difficulty is, as you've probably guessed, they failed to provide proper disclosure of the tenant's housing file. And after repeated requests from my solicitor, they still failed to provide the file. So he applied for and got an order for specific disclosure and inspection of the housing file. But they didn't comply with that order either. And again, after further repeated requests from my solicitor, they still failed to produce the housing file. So we took the unusual step of making a second application for specific disclosure. And this time we requested that a penal notice be attached to the order. And the order was granted in the terms that we asked for it. And then a few days later, without any prompting from us, the claimant withdrew its application for an injunction. We don't know exactly what happened, but my suspicion is that their chief executive found out the penal notice had been made, didn't want to expose himself to any risk of committal proceedings or contempt proceedings, and so told the housing officers to withdraw the application for an injunction. I mean, all along, all my solicitor and I wanted was a full copy of the housing file so that we could properly defend the client. But actually, we ended up getting what was a pretty good result. And while it might have been good to win that case on the basis of the substantive issues, the outcome was still the same. The client avoided an injunction being made, and as far as I'm aware, no possession proceedings have been brought against that client. So I think that's an example of how, in the right set of circumstances, tactical use of the CPR can yield really good results. And so with that in mind, that's why I'll be focusing on disclosure and inspection in this part of the webinar. And by disclosure, I'll specifically be dealing with disclosure and inspection under two parts under CPR 31. That's, well, I'll be dealing with standard disclosure in general terms, but also applications for specific disclosure and inspection, and also applications for inspection of documents that are mentioned in a party's statement of case or their written evidence. And then moving away from part 31, I'll also be dealing with disclosure, this time with non-disclosure in without notice application injunctions. But before covering those topics, I just wanted to mention briefly the issue of proportionality. And just a reminder that standard disclosure introduced under the civil procedure rules restricted the disclosure that had ordinarily been required under the old county court rules and rules of the Supreme Court. The idea being that under the civil procedure rules, disclosure would be more proportionate. So this is really just a reminder that if you're considering applying for any of the applications that I'll be discussing, as with any other application you make in proceedings or any steps you may take in proceedings, it's worth remembering just to reflect on whether or not what you're asking for is proportionate. But then moving on to the topics themselves, the notes and on the screen, you'll see a reminder of some of the basics of disclosure. But it is worth, I think, reminding ourselves of what documents are covered by standard disclosure. And this is dealt with under Rule 31.6. And that sets out standard disclosure requires a party to disclose the documents on which that party relies, to disclose the documents which adversely affect that party's case, adversely affect another party's case, or support another party's case. And also there's a requirement to disclose documents which are required to be disclosed by a relevant practice direction. Ordinarily, what documents are actually covered by standard disclosure will normally be based on the allegations that are contained in the parties' statements of case. And that's really going to be the main deciding factor of what the issues are and what the scope of standard direction is that's required. Disclosure does require a party to make or to carry out a reasonable search for documents, but they are only required to disclose those documents which are or have been in their control. Now, as previously stated, disclosure must be proportionate, and so that does mean that the court can limit disclosure to less than standard disclosure if it would be proportionate to do so. And despite what I've said about proportionality, I've rarely had a contested housing case where standard disclosure applies, where it would actually be appropriate to agree to something less than standard disclosure. So the bottom line is, if you've got a contested housing case, particularly a Part 7 case, then you should be asking for disclosure and you shouldn't be agreeing to anything less. That would be my guiding principle. But it is worth remembering that a party is only required to provide disclosure if and to the extent the court directs. So what that means is if you want disclosure, you may need to request it specifically, particularly in applications, for instance, applications for injunction or committal applications, where directions, particularly directions for standard disclosure or any disclosure, are not routinely given. Standard directions normally provide for disclosure after the close of pleadings, and also the duty to provide disclosure continues throughout the proceedings. And if there is standard disclosure provided in accordance with a court order, but subsequent disclosure is made, I would also suggest that you require the other party provides an amended disclosure list or a supplemental disclosure list. In terms of some of the issues that might arise around disclosure, one is the timing of disclosure, because ordinarily disclosure will be provided after statements of case have been filed and served. But in some cases, you may want disclosure early. You may be entitled to disclosure early, for instance, where there's a pre-action protocol. In other cases, even where you don't have an absolute right to early disclosure, you may still want it anyway. And whether or not you can get it and whether or not you can get it in the time scale that you want really depends on the circumstances of the case. And most legal representatives I know will try a subject access request as an alternative means of getting disclosure, but that really depends on whether or not you have the time to allow for that request to be complied with. But I have also had cases where early disclosure has been agreed, so that might be worth trying with the other side. I mean, I've had it agreed, for instance, in a case where client lacks capacity And so preparing a defence or a counterclaim would have been difficult without disclosure, because instructions from the client weren't going to be forthcoming. And so really a lot of the material needed to respond to the claim was likely to be contained in the housing file itself. If you need early disclosure, then one provision under Part 31 is 31.16, and that makes provision for applying for disclosure before proceedings begin. But that is providing the applicant and respondent are likely to be parties in the proceedings, the documents sought come within standard disclosure, and disclosure before proceedings will fairly dispose of the anticipated proceedings, help to avoid the need for proceedings, or save costs. I think the case that I've just referred to, or the example I've just referred to, probably comes within the first one of those examples. In other words, disclosure before proceedings will fairly dispose of the anticipated proceedings if in reality you need the housing file, or you need some level of disclosure in order to bring a case on behalf of your client. Under the CPR, there is scope for the parties to agree how disclosure should take place. For instance, it could be just by copy documents rather than the usual list and then inspection. But I would suggest that it's rarely appropriate, again in a housing contested case, to dispense with disclosure list, even if it is by copy documents. Therefore, that should be accompanied by the list, because the list will provide you with a breakdown of what documents have been provided. And although there's no absolute right to an individual itemization of each and every document, for instance, that's contained in a housing file, it will give you a working list of the documents that have been provided. And if, for instance, you do have a disclosure list from your opponent which provides, which sets out perhaps just a handful of documents, and then the class of documents is the housing file and contains maybe hundreds of pages which consist of the housing file, if you consider there are any documents that should be in the list, or that should be part of the disclosure when you get, or if you consider it should be part of the documents provided for inspection, but a particular document isn't included in the documents provided for inspection, then that is something that you can initially start by dealing with in correspondence with the other side. And the example I've got in mind, again, perhaps might be if you're dealing with a disabled tenant, but there's no proportionality assessment anywhere within the housing file. You may just want to point out the absence of any assessment in the housing file. You should then hopefully get your opponent's response on that, either confirming that no assessment was done, which will then normally leave them scurrying off and getting a belated proportionality assessment done, which should then hopefully be disclosed to you. But if what happens is the landlord says there is no proportionality assessment, then that correspondence should be included in the trial bundle if the matter eventually goes to trial. And this is really part of the reason why I would suggest not only any correspondence about disclosure or inspection goes in the housing file, but also the disclosure list itself should be included in the housing file. Because the most likely scenario at trial where disclosure becomes an issue is a housing officer in their oral evidence to court refers to a document that hasn't been disclosed. If that happens, the most straightforward way to establish it hasn't been disclosed is to take that housing officer to the disclosure list in your trial bundle, or to any correspondence dealing with disclosed documents or inspection that there has been between the parties. So that's the main reason why I would say it's important to include the list itself and correspondence dealing with the list and inspection in the trial bundle. But ahead of trial, the most likely problem to arise with disclosure is your opponent's failure to provide proper standard disclosure, which theoretically shouldn't happen where the other side is legally represented, because under Practice Direction 31A, this is paragraph 4.4, it says, if the disclosing party has a legal representative acting for him, the legal representative must endeavour to ensure that the person making the disclosure statement understands the duty under Part 31. What sometimes happens in cases is you've had disclosure, you've had inspection, but you are fairly confident that there are some documents missing. You raise it with your opponent and your opponent says, or is fairly dismissive and simply says, well, look, we're under a continuing duty of disclosure, so if the document turns up, we'll disclose it if and when it turns up. Now, depending on how important that document, the missing document is, or the document that you think is missing, depending on how important it is, you may accept that, or you may actually just remind them that if the document does exist, then it's their duty to carry out a proper search to establish that document does exist and provide inspection of the document itself. The next way then, if that doesn't help, then the next stage in dealing with inadequate disclosure is to make an application for specific disclosure. Now, an application for specific disclosure and specific inspection, it can arise in a couple of scenarios. It may be appropriate, for instance, where the other side has failed to disclose all of the documents covered by standard disclosure, or it may be appropriate where they have redacted some of the documents provided for inspection, but you consider or you object to the redactions you object to the redactions included in the documents. Where we're dealing with information within documents that have been redacted, the same test for standard disclosure under 31.6 is that it's the same test that applies to redactions. So in other words, a party should not redact information that it either relies on, that would support another party's case, or that would adversely affect any other party's case. And leading on from that, it's also important to remember that confidentiality on its own is not a ground for withholding disclosure, or it's not a sufficient justification for redactions. And again, the use of redactions, particularly in antisocial behaviour cases, is becoming an increasing feature of the disclosure and inspection that's provided. And again, a typical justification is that there's been redaction of, for instance, a complainant's identity because the complainant wants to remain anonymous. I would say that I've had redactions in cases where only some redactions of a particular complainant's identity have been applied, and therefore it has actually been possible to identify who the redactions relate to. Or there have been other instances when there is other correspondence amongst the inspected material where witnesses have said they are willing to come to court to give evidence, although they may not have made a witness statement, and nonetheless the housing officer or legal representative decides it's appropriate to redact their identity. But whatever the circumstances, it seems that if standard disclosure, if the information is relevant, assessed against 31.6, then the redactions themselves ordinarily would not be justified. But one potential difficulty with applications for standard disclosure, specifically as opposed to inspection, is you may believe that a document hasn't been disclosed, but it sometimes can be difficult to be sure whether or not the document has not been disclosed because the document itself doesn't exist, or whether or not the document does exist, it just hasn't been disclosed. but you will need pretty, good, solid grounds, well, reasonable grounds, if you do want to make an application for specific disclosure, because the courts won't or are unlikely to entertain a speculative application for specific disclosure. But in most cases, you will have a good idea of the documents that you would expect to be in the housing file. And so alarm bells might start ringing if the expected documents aren't provided in your list or aren't provided during inspection. Before making an application for specific disclosure or inspection, you'll normally be expected to notify the other side that you consider their disclosure is inadequate, ideally providing your reasons for considering their disclosure has been inadequate. For instance, by highlighting the documents or the class of documents that you consider are missing, or raising what your objections are to redactions that there may be in the documents provided. You should also give the other side an opportunity to remedy the inadequacies you've pointed out, either by providing a supplemental disclosure list, providing the requested inspection, and within your pre-application correspondence, you should also warn them that you will make an application for specific disclosure unless you receive the requested disclosure or inspection. And then if they still fail to provide the requested documents, then it may be appropriate to go ahead with your application for specific disclosure. The notes do set out, the seminar notes do set out the procedure for making an application for specific disclosure, which is actually set out in more detail at paragraph 5 of Practice Direction 31A. As to whether or not you'll succeed in your application, my experience is that if you have a reasonable application for standard disclosure, then perhaps not surprisingly, you can expect to succeed in that application. And what the practice direction says is that if the court concludes that the party from whom specific disclosure is sought has failed adequately to comply with the obligations imposed by an order for disclosure, the court will usually make such order as is necessary to ensure that those obligations are properly complied with. And that's certainly my experience in making those types of applications. And as my example at the outset suggests, if you make an application for specific, if you have to go to the lengths of making an application for specific disclosure, and the other side still fail to comply, and you're required to go to what are the extraordinary lengths of making a second application for specific disclosure, then you really should be thinking about imposing or asking the court to impose some sort of penalty, either with a penal notice or maybe with an unless order, and maybe even throwing in there a request that if your application is successful, that you should recover costs on an indemnity basis. Which I would just throw in, actually, the other side did agree to in that case I referred to. They did agree to that ahead of our application, our second application for specific disclosure. So I'm going to deal briefly with redactions, and this is really just to remind ourselves that when material is redacted, if that material falls within the test for standard disclosure, then the redactions are inappropriate and unredacted copies should be provided. The main authority really for dealing with redacted documents and obtaining inspection of unredacted copies is WH Holding Limited versus E20 Stadium, and the case and citation is in the notes. And then the final part, or the final aspect of Part 31 that I wanted to deal with is applications under 31.14. And this is in relation to documents mentioned in a statement, in a party's statement of case or their written evidence. And so this specifically applies to documents that are mentioned in the statement of case, a witness statement, a witness summary, or an affidavit. And when the document's mentioned, it normally triggers a right to inspection of the document. As to whether or not a document has been mentioned, I mean, that really is to be given its ordinary meaning. But if the document mentioned or is mentioned either by specifically identifying the document or making direct allusion to the document or a class of document, then the right to inspection is probably going to be triggered. What it means is that reliance on the document itself is not necessary. But what would be insufficient is if there is an indirect reference, or if there is an inference that a document exists, that probably would be insufficient to trigger the right to inspection. As with applications for specific disclosure, and really with most applications you intend to make under the CPR, again, you will probably, or you would probably be well advised to put your opponent on notice that you consider you have grounds to make the application and formally request that they comply by providing inspection of any documents mentioned in their statement of case or in their written evidence. And then if they fail to provide the documents, then making your application. And if we're dealing, for instance, with a document that has been mentioned in particulars of claim, ordinarily you should get that inspection before having to file and serve your defence. And again, the court seem willing to acknowledge that if you have a solid basis for applying for inspection under CPR 31.14, then actually you really should get the documents, and they do normally direct that the documents are provided before you need to provide your defence. I'm going to leave part 31 for now and now deal with the final topic, which is non-disclosure in without notice injunctions. Now, although I've quoted the case of Moat Housing Group and Harris, which dates back to 2006, where it says that granting without notice injunctions are an exceptional remedy, still think that to a certain extent that is true, but my experience is granting injunctions. Sorry, I forgot to move on to the final PowerPoint. But my experience is that social landlords are increasingly making use of without notice or obtaining without notice interim injunctions. Moat is an example of how they might do so when really the basis or the evidential basis for doing so is completely inadequate, particularly compared to the scope of the injunction or the terms of the injunction being sought. But actually, the focus of this part of the webinar is really to deal with the duty of full and frank disclosure that an applicant is under when they're making these types of applications without notice. And the idea behind the duty of full and frank disclosure is to mitigate against the potential injustice that results from the court hearing only from one party on the application. The notes deal with some of the background or elaborate a little on what the duty encompasses. And the main authority is Brinks Mat Limited versus Elcom, which again dates back to 1988, but it still seems to be the main authority, and it's certainly still the one that's cited at length in the most recent edition of the White Book. So I'm just going to finish really with this section by summing up the approach that the Court of Appeal took to material non-disclosure and its consequences for applicants who fail to comply with the duty of full and frank disclosure when making without notice applications. And so the main principles are these: that the applicant is under a duty to make full and frank disclosure of all material facts. Material facts are those which it is material for the judge to know when deciding whether or not to grant the injunction. And just pausing there for a moment, in housing cases, the most likely example, or the most obvious example that I can think of now, is the landlord may make an application, a without notice application for an injunction based on allegations made against your client. Your client may have also reported allegations to the landlord, and those allegations may well be against the complainant whose evidence the landlord is relying on. The landlord should, under the duty of full and frank disclosure, obviously include those allegations as part of the evidence and bring those counter allegations, if you like, to the court's attention. Because that, of course, may be material in whether or not the judge decides to grant the injunction without notice, or whether or not actually a judge adjourns it to give notice to the other side to hear representations from them. But going back to the guidance from Brinks-Matt, the duty of full and frank disclosure covers material facts known to the applicant and material facts which the applicant would have known if proper inquiries were made before making the application. So it's not enough for the applicant to say, well, I did disclose all the facts I knew about. The onus is on them to ensure that they acquaint themselves properly with all material facts. But what amounts to a proper inquiry depends on the facts of the case, taking into account the nature of the case, the order being sought and the probable effects of that order on the defendant, and the time available to make inquiries, which may be reflected by the urgency of the application. But the court will wish to avoid an applicant benefiting from any material non-disclosure where a breach of the duty of full disclosure is established. That said, whether non-disclosure justifies revoking the injunction depends on the importance of the non-disclosed fact and whether the non-disclosed fact was deliberate or whether it was innocent, in that the applicant was unaware of the fact or unaware of its importance. In reality, it seems that where there has been a deliberate material non-disclosure, a without notice injunction is at greater risk of being discharged or being revoked. And obviously the latter means that any committal applications or committal order would also be discharged. But it is possible that a sufficiently serious innocent material non-disclosure may result in a discharge of the injunction as well. As far as material non-disclosure is concerned, I've dealt with that mainly in the context of antisocial behaviour injunctions, but of course it would apply to any injunctions that are made without notice. And for our purposes, it may well apply, for instance, if you're making a without notice application in an unlawful eviction claim. But at this stage, that's my part of the webinar dealt with. So I'll now hand over to Nick.
Hello, everyone. I hope you can see my screen that I am sharing. I'm Nicol. I'm going to deal with the second part of this seminar, dealing with pleadings and witness statements. I've put a couple of things in the chat. First of all, it's a case which is supplementary to what Patricia was just talking about, disclosure. Will Flack, a solicitor at Morrison Spowart, has had a problem for years with how local councils and housing associations disclose their documents. And this was an opportunity to get it sorted. Lambeth Council were sending him documents by egress, which some of you may have come across before, a document sharing site used by local authorities. Not only did he have problems using egress, but the documents were all sent higgledy-piggledy without any structure or form that could be followed. And in the case of Lambeth against Fowl Boston, there's an argument about costs. And it was held that Lambeth hadn't disclosed their documents because they hadn't complied with a CPR practice direction, I think it's 6A, in which when they use an electronic form of communication, they had to check with the recipient that they were happy to use egress first. And of course, Lambeth hadn't done that, they just imposed it on Will. So that is a useful case. The references say is in the chat. It's a county court decision by His Honour Judge Leatham, but we got it reported in legal action, and the reference is there in the chat function. I also put in the chat function the link to our notes for this webinar, which I hope you can all download. There is also a feedback form to follow. I don't have the link for that. If while I'm talking, Patricia could look for that and put the link to that in the chat, that would be very useful. One of our participants, Michael, has provided that form. Okay, well, first of all, an apology. What I'm going to talk about is substantially, not exactly the same, but substantially the same as a talk I gave previously about witness statements. If you have heard my talk about witness statements before, you're free to leave early, unless you would like a refresher. It's something I think my colleagues in chambers roll their eyes in their heads how I go on about how witness statements are badly produced, but it is something which I think is important because I don't know about you, but the quality of pleadings and witness statements, particularly from social landlords, is absolutely awful. And you have to wade through reams of stuff which shouldn't be there, documents which are attached which shouldn't be there, and loads of other material, particularly in witness statements, which shouldn't be there. And this just complicates matters. It takes you longer to read the documents, particularly when it comes to preparing the trial bundle. It's a nightmare to have to organize things. And if you're the defendant, it's a nightmare to get the other side to organize things properly. You end up with huge bundles with multiple repeated documents because they're attached to the pleading, the witness statement, and then they have to be shown separately. It's a problem. The problem with getting the courts to deal with defective pleadings or witness statements, though, is the other side of the coin. Look, this is just the county court. Let's get on with it. We don't need to bother too much. That I, as the judge, can ignore the parts that are defective. But I think it's very important to get your shots in early about the flaws in pleadings and witness statements. At the very least, it may advantage you when it comes to arguments about costs. But hopefully, you can get parties to put their pleadings and witness statements in proper order so that you can actually follow the case properly, so that you can run the case properly. So looking first of all at pleadings, there is a relatively recent case, Tueje and Fitzroy Place residential. Mr. Justice Pepperell looked at an application to strike out part of the particulars of claim. And what the claimant managed to establish spectacularly was that they and their legal representatives didn't know what should be in a pleading. Mr. Justice Pepperell was happy to correct them. So they argued that the particulars of the defendants replied. So they argued that the claimant had failed to show any causative link between the alleged breaches of contract and losses. No expert evidence was provided. Details of steps to mitigate losses hadn't been pleaded. The evidence didn't support some of the allegations, and some of the losses included double recovery. And the basic point being made was, well, first of all, with the strikeout application, you're supposed to assume the contents of the pleading are actually true, and therefore not being supported by evidence is just irrelevant. But there's a lovely bit where Mr. Justice Pepperell said, every bar student is taught that they should plead facts and not evidence, but it is regrettably a distinction that is all too often lost sight of and is increasingly responsible for extraordinary prolixity in pleadings. Very judge-like language. He's saying far too much is stuffed in the pleading. And if you get a defense to counterclaim from the local authority or something which endlessly repeats the evidence over many, many pages, then write to the other side and say, this is a misconceived pleading. I'll happily allow you more time to replace it, but if you don't, I'll raise this on costs. A point about pleadings is I am often asked, do we need to put in a reply? And in my opinion, the most overused pleading is a reply. Under CPR 16.7, basically, if you don't respond to a defense, everything is automatically traversed. It is assumed you oppose everything in the defense. So unless you've got some specific point to raise that would otherwise take the other side by surprise, there is just no point in a reply. And you should save yourself time and money by not bothering with that. I think there's a temptation to think that if I don't get my point in now, maybe I won't. But you should trust in the process. There will be an opportunity to say your piece later. I also mentioned in the notes the case of Redbridge and Courier. As often happens in ASB cases, I think all the problems I'm talking about are at their worst. The local authority attached a witness statement to their particulars of claim. And the judge in that case reiterated that a witness statement and statement of case are two different things. And I've come across worse than just a witness statement being attached to the particulars of claim. And there's nothing wrong in an ASB case with the landlord filing at court at the same time their application for an injunction and the witness statement that supports it. But that's not the same thing as having the particulars of claim, having the witness statement attached to it. I have had situations where the particulars claim essentially say everything's in the witness statement attached. You can't plead to a witness statement. A witness statement contains lots of things. It's just impossible to plead to, and it is something which shouldn't be allowed. So just on the screen there are the two cases I refer to in relation to defective pleadings. But moving on to witness statements. It's worth bearing in mind what the CPR says, what a witness statement is. It's a written statement signed by a person which contains the evidence which that person would be allowed to give orally. It's just meant to be a replacement for the examination in chief, which prior to 1998 or whenever witness statements came in, was how a witness would present their evidence first of all. Witness statements now seem to be regarded as an opportunity to introduce submissions. Particularly local authorities, my council thinks this, that, and the other, or we've got all these policy issues that we need to discuss or something like that. None of that should be in there. And it is interesting that the White Book specifically states in the commentary, unfortunately, rules, practice, directions, and guidance as to the content of witness statements appear to be habitually ignored by practitioners. Periodically, the Court of Appeal and individual trial judges have criticized lawyers for overloading witness statements with material that should not be included. Now, I managed to persuade one judge to strike out a witness statement that abused the appropriate rules, but the more common attitude I've had from judges is this is a matter for the trial judge, leave it at that. But I have had a situation where I have then gone to the trial judge and said, you can't have this witness. This witness statement says nothing relevant to the trial. They just repeat all the documents, which we can all read for ourselves. There's just no point in having this witness. My opponent then stands up and says, aha, but this witness can explain various documents. And I said, well, if they wanted to explain various documents, that should have been in the witness statement. They're now trying to introduce evidence which they haven't previously disclosed in accordance with the rules. The trial judge allowed the witness in the witness box, and the witness gave all sorts of evidence of which we had had no advance notice whatsoever, and some of which we would have liked an opportunity to respond to. I think it's important to try and get these procedures right on the earliest occasion. There will be occasions when it comes down to it, when you will be disadvantaged. Again, it's a matter of trust. There are reasons all these rules are in place. And if they're not followed, at the end of the day, someone is likely to lose out. And therefore, I think it's important to point out the flaws as soon as they appear. I mentioned in the handout the quote in Cummings and Ministry of Justice that having witness statements, which includes matters irrelevant matters, has strong tendency to increase costs and delay. And I think that's something that should be emphasized. I think the main reason for getting the other side to put their evidence in order is so that you can understand it. The biggest problem I have, particularly in ASB cases, is the way they'll produce evidence which has multiple hearsay, which is impossible to test because of the lack of detail of where it comes from. And it's only by pushing at an early stage for witness statements to be put in proper order that you can understand the case you're going to meet. To give you another example of unintended consequences of not doing that early enough, I had a case where the local authority relied on a housing officer telling us what the principal complainant had said, either in documents or verbally to her, and just made a general allegation she's too scared to come to court. Now, the principal complainant lived next door to the defendant. There was no doubt they knew each other. They had daily interaction. It was one of those streets where your front door opens immediately out onto the street and you're right next to each other, with only a thin wall in between you and continual complaints back and forth of noise nuisance. And she was the only complainant. So there was no doubt they knew each other. They interacted on a daily basis. Why that person couldn't come to court, I don't know. But the witness statement was seriously defective. And I made that point in my skeleton argument, which the judge read. And I don't know whether the judge had thought of those issues himself anyway, or whether he took it from my skeleton argument. But his solution to this was to have the housing officer stand up and ask her why this complainant could not be brought to court today or the next day that we had scheduled for the trial. So I'd prepared the case on the basis this person wasn't coming to court. The next day, they were at court at the behest of the judge. And I had to face a case, my client had to face a case, which was completely different from the one we'd prepared for. In the end, we settled because the judge wasn't happy with how the local authority had run the case. But we had our legs chopped out from under us. And that's why it's really important to try and tackle witness statements at an earlier stage. It's not just a matter for the trial judge to deal with, because then you'll get idiosyncratic decisions like that one. It's also, I've been talking about the flaws that you see in the other parties' pleadings and witness statements. But it's also very important that obviously you get your own witness statements and pleadings in order, that you follow these rules too. And the most common errors I see in witness statements on my side of the fence are not the kind of problems I've been talking about, where there's lots of hearsay and the witness saying consists principally of reciting what's said in various documents. Instead, witness statements I see from my own instructing sisters tend not to comply with the formal requirements. If you go to Practice Direction 32, paragraphs 17 to 25, there are various formal requirements, and it's worth just rereading them to yourself to remind yourself what actually needs to be in a witness statement. One of the requirements, for example, is that in the top right-hand corner, you have to have various details, including the party on whose behalf the witness statement is made, the initials and surname of the witness, the number of the statement in relation to that witness, the identifying initials and number of each exhibit referred to, and the date when the statement was made. That's often not there. And then there are various other requirements, and the latest requirement that should be in a witness statement, as well as the full name of the witness and the witness statement, the witness's place of residence, things like that, is the process by which it was prepared. This is a recent requirement, recently come in. So whether the witness statement has been prepared face-to-face or over a video link, with the assistance of a solicitor or by the client themselves, with the assistance of an interpreter, matters of that sort all have to be mentioned towards the beginning of the witness statement. I also see that there's a requirement that this statement should say whether matters in it are from the witness's own knowledge or not. But that is often routinely ignored. So you'll have a standard statement at the beginning. I'll say when this is from my own knowledge or not. And then later on, various things are said, and you read it and you think that can only have come from someone else, but they haven't mentioned who it's come from or how they know this. So it's very important that you should deal with that. And that is also a problem you see with housing officer witness statements. There are also formal requirements for exhibits, which are routinely ignored. I had an argument just last week about the witness statements for trials. Witness statements for trials should not have any exhibits. There isn't a particular rule to that effect, but the Chancery Guide and the guide for Court of Chancery and the Technology and Construction Court Guide, which both reflect good practice generally, both say that there should be no exhibits to statements which are being used at trial. The main practical problem is that, as I mentioned earlier, you then end up with multiple copies of the same document and trial bundles which go on forever, because each of the witness statements have lots of exhibits which then must have to be somewhere else in the bundle to be in chronological order. But it was suggested that when this was argued, that you need to have exhibits to witness statements because the witness needs to prove the document. Otherwise, the document might be disputed. But that is not how it works at trial. Under Practice Direction 32, paragraph 27.2, all documents contained in bundles which have been agreed for use at a hearing shall be admissible at that hearing as evidence of their contents, unless the court orders otherwise or a party gives written notice of objection. So basically, if a bundle of documents is prepared for trial or for another hearing, and you've agreed the contents of that bundle, you are agreeing that those documents are what they appear to be. So for example, if a document appears to be a letter sent on the 2nd of July 2020 from the other side to your client, that is what it appears to be. You are saying, yes, that is what it appears to be. You might not agree the contents. The contents might accuse your client of various things which are not true. That's a different matter, but you are agreeing it is the letter which it purports to be. And therefore, it doesn't need to be exhibited because it doesn't need to be proved. It is already an admissible document. So what should not be in a witness statement? This all comes from the case which I rely on quite regularly, of J.D. Wetherspoon and Harris, which is labeled as a practice note, although it just reads like an ordinary judgment. But it warns against and says it's abusive to have a recitation of the facts based on the documents, commentary on those documents, arguments, submissions, or expressions of opinion. I recently had a witness statement where the local authority surveyor, not qualified as, it's just their job title, basically set out in a witness statement their opinion of all the various items of disrepair. It was a purely opinion matter. There were a few facts in there on the basis of which he gave his opinion, but that is an opinion statement. It's not a witness statement. He wasn't approved as an expert witness. Indeed, there was already a single joint expert, and it was totally inappropriate. And as mentioned in the notes, in the case of Baron and Nicol Housing Trust, we got a witness statement to this effect struck out. But that was on the basis, I argued it and the judge accepted on the basis that they could replace the witness statement. In other cases, as I mentioned, the judges said, well, it's a matter for the trial judge and the trial judge will be able to distinguish the parts that are abusive. But I still prefer the approach that I managed to persuade the judge in that case to take. And it would be useful if more people tried that. What should you do if you do receive a defective witness statement or pleading? First thing, write to the other side objecting, pointing out all the problems with it, which, judging on my experience with local authorities, they'll say, no, you're wrong, we're absolutely fine. But as I say, I think it's important to get your shot in early. If it is a particularly bad example of a witness statement or pleading, then I would say apply to have it struck out, which there's no doubt that the court has the power to strike out an abusive witness statement. And if there is sufficient time for a replacement statement to be brought in, then you can apply for not just the striking out, but for new directions for new witness statements. And by the way, I've used that as a tactic when I've been dissatisfied with the state of our own evidence. You can point out the flaws in the other side's evidence and say, let's have a new direction as to witness statements. You replace yours, and then we can replace ours or add to ours as well. And it allows you to fill in the gaps in your evidence without having to justify being late compared with previous directions. I mentioned before problems with housing officer statements and NASB cases and social behaviour injunction cases. And there is a serious problem, it seems, amongst local authorities as to what they can do with hearsay evidence. There seems to be this attitude that since hearsay evidence is allowed in, we can stick anything in we like. That's not how it works. Patricia already mentioned the case of Moat Housing Group South and Harris, which is definitely worth looking in. That in that case, they said a party adducing hearsay evidence should state in direct evidence why it was not reasonable and practicable to produce the original maker of the statement. Now, on that one, they assume that there is a statement at all. What you normally get is housing officers saying neighbour A, B, and C told me X, Y, Z. But what you normally get is some kind of bland statement they're afraid to come to court. I've had several judges say, look, if they come to court, we've got various things we can do to protect them. They can give evidence from behind a screen, on the other side of the court, by video link if necessary. If it's simply coming to court that's a problem, that's never going to be sufficient basis for not calling them. There's got to be some rational basis for not bringing them to court. And it should be remembered that under Section 4 of the Civil Evidence Act, there are various criteria by which to measure the weight of hearsay evidence. And the first one is whether it would have been reasonable and practical for the party by whom the evidence was adduced to have produced the maker of the original statement as a witness. And often there isn't sufficient basis for not calling them. There certainly isn't normally a sufficient basis for getting them to make a witness statement. So even if someone doesn't come to court, they can still make a statement. If they make a statement, at the end of it, they have to sign the new style statement of truth, saying that they'll be subject to contempt of court if they don't tell the truth. That's going to weigh heavily, I would have thought, in anyone's mind before they sign it. And it should help to produce better quality evidence. In one particular case, the housing officer said, I couldn't get them to do a witness statement because if they did a witness statement, they would have to come to court, which is, of course, complete nonsense. You can have hearsay evidence given in a witness statement. You can anonymize the witness statement if you want, but the fact that it's in a witness statement should substantially improve the quality of the evidence, in particular by requiring the witness to have approved and signed it with the statement of truth. So I think it's very important to look at that evidence and again to object to it at the earliest possible stage. You can, as I mentioned earlier, argue it all out at trial and undermine the quality of evidence by pointing out the ways in which the evidence does not match the criteria in the Civil Evidence Act. But as I have also said, that produces sometimes unintended consequences. So those are the things I wanted to say. Do we have any questions that anybody would like to ask? You can put them in the chat. I notice in the chat that very helpfully we've got information from Michael Marshide about upcoming webinars that we are also running. There's a point made by Rachel Lovell from Lewisham and Southwark Law Centres saying, I'll just read it out, read foreign language witness statements. CPR 32, Practice Direction 32, 23.2 would seem to require that it is completed in the foreign language first and then translated to English. In reality, it would be very hard to do it that way round if the solicitor is not a speaker of that language and sure it covered relevant matters appropriately, exhibited the documents, etc. Is it sufficient that, whichever way around it is started and completed, that there is a final version in the foreign language and a final version in English, and that the translator certifies that the English version is an accurate translation of what is in the foreign language version? Now, I think this comes from our good friend and erstwhile colleague, Judge Luber. Let me just get the relevant part of the CPR in front of me. So my internet's being slow now. My own feeling is that Judge Luber is being, as is his wont, very specific about his interpretation of the practice direction. I agree entirely that it's not feasible to prepare the foreign language version first, because the point is that the you, as the advisor helping to prepare the witness statement, needs to know what it says. Yeah, I just reading the wording of 23.2, I don't see any problem with preparing the witness statement in English first, having it translated, getting the client to approve it, and then getting it retranslated or amended in accordance with whatever amendments have been made. The greater difficulty I have, which is a problem with both foreign speakers and native English speakers, is the tendency to regard a witness statement as the lawyer's document. And when the lawyer presents it in front of you, you just have to accept what it says. The thing is that the primary consequence of using witness statements for barristers is that you are armed with the knowledge that this statement was not prepared by the person you're talking to in the witness box, the person that you're cross-examining. You know that there will be differences between that person's understanding of the case and what it says in the witness statement. And the more that the witness statement reads like a lawyer's statement, the more certain you can be that there will be differences. And in the most recent case I was involved in was a typical example where the entire cross-examination consisted of trying to find gaps between the evidence of the person in the witness box whose English wasn't great and the witness statement. Mm-hmm. And they succeeded in making a number of points over the witnesses because it wasn't the witness's document, it was the lawyer's document. And therefore, other than urging clients to pay attention, it's difficult to know quite how to get over this, but I think it's very, very important to make clients and witnesses understand this is their document. Yes, the lawyer has helped draft it, but if there's anything in there that they don't understand or phrased in a way that they would never say it, or that is wrong or slightly, not the way they would put it, then it has to be corrected. Otherwise, it will be exploited in cross-examination. And obviously, those problems can be exacerbated when you've got something translated from one language to another. I think the next question in the chat's for you, Patricia. What would happen in the event if the document redacted is no longer in control of the person who disclosed it?
Yeah, thanks, Nick. And this is from Nasrat Mir. I think the answer to that question might be CPR 31.8. What I'm assuming from that question is that if the document has been disclosed, albeit in a redacted form, then it was disclosed by somebody who did at some point have the document within their control. And I think 31.8 applies because that really says that the duty, well, the heading of 31.8 is a duty of disclosure is limited to documents which are or have been in a party's control. So even though the person disclosing the document no longer has it in their control, the fact that they did have it in their control means that it is the subject of, means it would be subject to standard disclosure. I guess there's a further difficulty would arise if the person who disclosed the document never had an unredacted copy, and therefore they never had an unredacted copy within their control. I'm not sure that would exempt them from providing an unredacted copy. The reason I think that might be the case is because the full reading of 31.8, it's a fairly short paragraph. A party's duty to disclose documents is limited to documents which are or have been in his control. For this purpose, a party has or has had a document in his control if it is or was in his physical possession, he has or has had a right to possession of it. But this is the bit I think that might apply in this scenario, or if he has or has had a right to inspect or take copies of it. I would suspect that somebody who has had physical possession or control of a copy would have a right to inspect the unredacted copy and also would have a right to take a copy of the unredacted document. And if that is the case, then the fact that they no longer have physical control of the unredacted or physical possession of the unredacted document, I don't think that exempts them from the requirement to provide it under standard disclosure.
Can I add a couple of things? There's something that must be remembered. Disclosure is not the process of producing the document. It is the process of saying you have it or used to have it. Inspection is the process of producing the document. And I have had, on a number of occasions, it said that I can't disclose the document because I don't have it anymore. So that is why I didn't list it in my list of documents. So because it means I can't disclose what I don't have. No, disclosure is simply the process of listing it. So when it comes to disclosure, they're supposed to say whether they used to have a redacted copy in their possession, or if they have an unredacted copy in their possession. Whether they produce it is another matter. And in terms of getting documents from in terms of getting documents, I've also had the situation where a housing officer said, I personally don't have it. I run my own file here in my department. My department's file, which I run, doesn't have it. That's irrelevant. They're not the litigant. They're not the person you're suing. The person you're suing is the organization for which that person belongs. And therefore, even if it's not in that person's file, if it's in another department's file, then it is as if that person has the document. They have to disclose it and permit inspection. When it comes to third parties, you're talking about contractors, agents, that kind of thing. And yes, even if they're ex-agents or ex-contractors, there should be a right to see the documents. It's very difficult to imagine circumstances, I suppose, if a contractor sends in a redacted document and then goes bust and disappears into the wild blue yonder, perhaps you can't get the original redacted document. But I would have thought in most circumstances, the unredacted document at one point was in the possession of the person you're suing or in their control. Are there any other questions people would like to ask? Okay, well, it looks like not. I hope that's because our notes and what we said were so comprehensive that you don't need to hear anything further. But thank you to everyone for attending.
But before you depart, just a helpful reminder from Michael. I mean, I think Nick already referred to the list that Michael's put in chat for everybody to have a look at the whole host of seminars that we've got coming up. So please do take a look at that. But also the reminder from Michael is if you could please complete the feedback forms. There is a link, or there should be a link in the chat section. So if you could click on the link, complete the form and submit it to us, please, as the feedback will be very useful. And if you don't have access to the link, then if you could please just email maybe Scott or somebody at One Pump Court, and we'll provide you with a copy of the form. But yeah, there are still no further questions. So I think I'm going to assume, like Nick did, that that's answered, that our webinar and the paper has answered all the questions people have about how to deal with CPR tactically. Okay, so on that note, it's goodbye from me.
And goodbye from me. Thank you very much.